Hey everybody, welcome to this week's installment of What Does the Fox Say? Happy Friday. So I wanted to talk a little bit about the ruling that you probably heard about that strikes down essentially the entire Affordable Care Act. This ruling came out Friday, and this really goes back to a case that was introduced over the summer. It was brought by a group of Republican governors and attorney generals who were essentially arguing that since the individual mandate penalty had been eliminated, that the rest of the Affordable Care Act should be considered unconstitutional, which is a pretty bold claim, and I'm going to go into that just a little bit here. But Friday's ruling, which came very late in the day and also right before the end of open enrollment for many states, though not Colorado because our open enrollment goes through January 15th. What this ruling does, it doesn't change anything just yet, but it essentially looks at two big issues. One is a legal term called severability. And that is essentially a concept in law that says if you can take out a piece of a law that is unlawful or unconstitutional or whatnot and leave the rest of the law in place, you should. And it means that that component is severable from the rest of the law. And Judge Reed O'Connor, who made this ruling on Friday, essentially said that it is not severable, the mandate penalty, even though Congress passed the individual mandate penalty repeal essentially through the tax bill that they passed at the end of 2017. So essentially what the judge is saying is that he's arguing that the 2010 Congress meant that the entire ACA rested upon this individual mandate penalty, and that Congress, essentially the 2010 Congress, was the one who should be essentially looked to for what the intent of the Affordable Care Act was, instead of the 2017 Congress, who tried multiple times to repeal the Affordable Care Act and ultimately decided not to do so, and they only zeroed out the individual mandate penalty. So you have a weird scenario going on where the judge is arguing that this component that is really a small component of the Affordable Care Act in the scheme of things is not severable from the rest of the law, and therefore the rest of it is unconstitutional. And he's simultaneously arguing that the Congress in 2010 should be more believed than the current Congress as to the intent of the laws that are passed, even though it's the 2017 Congress who zeroed out the individual mandate penalty that brought about this whole law or whole court case. So he's twisting himself really in a lot of legal knots in his justification, and he's known as a conservative judge that is looked to by those who want to bring cases like this to get a beneficial ruling to start the case. So what happens now? So this ruling happened on Friday. Nothing changes immediately with the Affordable Care Act while this court case is still in progress. So the health coverage options that people have now are still available. There's still financial assistance available in Connect for Health Colorado. There's still the expanded Medicaid coverage that's available for low-income families and individuals. All of that remains in place while this law or court case proceeds. It will almost certainly be appealed. They're sort of waiting for Judge O'Connor to finalize a few components of his ruling and clarify those before the appeals start getting filed, but the California Attorney General has already said he's going to file that appeal, and that's not surprising. We knew that that would happen. And we know that Colorado's incoming Attorney General, Phil Weiser, intends to sign on in defense of the ACA and join California and a number of other states to defend the Affordable Care Act in this lawsuit. The other thing that I want to talk about is that there are a lot of folks who, and a lot of news articles out there right now that say Colorado has protections for pre-existing conditions even if the ACA gets struck down by this lawsuit. And I want to look at that a little more closely because, yes, in 2013, CCHI and a number of other groups worked very hard to pass a lot of the consumer protections of the Affordable Care Act into state law. So we have guaranteed issue for people with pre-existing conditions. We have essential health benefits. We have a lot of those fundamental consumer protections of the ACA in Colorado law. However, if the ACA does get struck down through this court case, which admittedly looks relatively unlikely, if it's struck down, the funding for financial assistance, the funding for expanded Medicaid, and a number of other provisions that do affect our health insurance market would go away. And in doing so, it would leave essentially almost all of the individuals in Colorado that have gained coverage under the ACA, so around 600,000 Coloradans, would lose coverage or lose access to affordable coverage. So while we would still have the protections for pre-existing conditions and those things in Colorado law, they would be sort of meaningless for a lot of folks because they wouldn't be able to get coverage. They wouldn't be able to afford it. So it's very important that the ACA continues to get defended. And I think we'll see this court case go to the Fifth Circuit Court of Appeals. It's, I think, a question as to whether the Fifth Circuit will accept Reed O'Connor's ruling. I think it's a little unlikely, and there are a lot of legal scholars who think the Fifth Circuit may be the place where this court case ends, but it's certainly not a done deal. And if the Fifth Circuit upholds the initial ruling by this judge, then it would almost certainly be appealed to the Supreme Court. So the timeline is a little bit unclear as to how quickly this court case will progress. As I said, the appeals haven't even been filed yet, so there's a lot more ahead on this. What I do want to say is that even while the financial assistance and expanded Medicaid coverage and all of those things continue to exist while the court case is in progress, this court case does raise a lot of uncertainty for the insurance market. And that means that it could give insurance companies more rationale to raise rates because they don't know what's going to happen with this court case. And it really emphasizes the point that we need to do more at the state level to stabilize our insurance market, whether that's through a reinsurance program or creating a new state coverage option to make sure that our healthcare system is as insulated as possible from what is happening at the federal level while this court case proceeds, and also from whatever the Trump administration cooks up next. And that's all I've got for you today. We are going to be out of the office next week in between Christmas and New Year, so I will not be back next week. But we will be back in the new year on January 4th, and I'll probably be talking a little bit more about some of the state level efforts to improve healthcare and what you can do to get engaged in those. So I'll look forward to that. Happy holidays.